that breaking story now. The Constitutional Court has scrapped a law that caused many people to lose their South African citizenship when they became citizens of another country. The law, Section 6.1 of the Citizenship Act, meant that if you didn't get permission from the government first, you would lose your South African citizenship automatically. Immigration lawyer Ashraf Essop joins us now to explain what this means. Ashraf, welcome and thank you for your time. Well, the DA sought confirmation of a Supreme Court of Appeal judgment that declared some provisions of the Act unconstitutionally and invalid. Is that a correct premise to move from?
No, indeed it is. So what the Constitutional Court did was, in fact, upheld the unconstitutional declaration by the Supreme Court of Appeals. It's very interesting that the genesis of this entire matter started in the High Court some years ago. And there, the DA, the applicants, were not successful. They argued that automatic loss of citizenship is unconstitutional. The High Court disagreed with them. The High Court was of the view that there were mechanisms in place that prevented or mitigated against automatic loss, such as that you had to apply for permission, receive permission, and then only take up citizenship of a second state, another country. Now, what the premise of the argument for the applicants is that citizenship is so important, it's constitutionally guaranteed, that it is a gateway through which a number of other rights in the Constitution is accessed. And this was held by the Constitutional Court way back in 2020 in the matter of Shisius. Now, without being able to enjoy your constitutional rights, whether it's freedom of movement, trade, political representation, or specifically in terms of citizenship, every citizen has a right to citizenship. You have a right to a passport. You have a right to enter and leave the Republic. All of these rights are vouchsafed in the Bill of Rights. And the thought that you could automatically just be deprived of this by taking up citizenship through a voluntary means other than marriage and being a child, it was too drastic. And so they said, we're now going to declare, or we're going to bring an application to declare the provision unconstitutional. We know that they were successful in the Supreme Court of Appeal, but before a matter can be considered as an impunged provision, it has to go through the Constitutional Court, which is the situation that we find today's judgment addressing.
To those people who say, but why are we even arguing about this? Because if a person takes a decision to dump their country of birth and then go and live in another country, that's a choice that they have made. And I'm asking this without being flippant about it.
See, that's an interesting question, because I was also reflecting on how many people indeed are dual citizens of South Africa and some other territory. So, and who would benefit or who would be harmed by such a provision? And I guess that 80% of South Africans are still single citizens. They don't enjoy dual citizenship. So it's not that you're dumbing or dumping your South African citizenship or for whatever reason. It simply means that the Constitution doesn't prohibit dual citizenship. And the notion that the moment you do something innocently, you could have done it innocently, you didn't know about the 1995 amendment, and then you took up citizenship, as the court had referred to one of the applicants in the High Court, Mr. Plaatjes, who went abroad, fell in love, married there, took up UK citizenship, and then when he went to renew his passport, only to be told, sorry, you're no longer a citizen because this is an automatic deprivation or loss of your citizenship. And the court was saying, no, citizenship is too important a notion for you just to be automatically debarred from your rights of citizenship. I think that's correct. It's not based on whether you decided not to continue living or were not patriotic to South Africa. It is a right that you enjoy, and this is very, very important. The rights that are vouchsafed in the Bill of Rights always require protection, and indeed, every law and every act should be viewed through the prism of the Constitution. So I understand the notion that very few people will benefit by such a ruling, but it's important to understand that this ruling goes back retrospectively. It says anyone that lost their citizenship since October 6, 1995, can now say that we never lost it. So it's in effect, it's retrospective.
But then, did people not have any form of recourse in terms of the law that has now been invalidated? Did you not have recourse? In other words, could you not say, well, to use the example you just used, I fell in love, took up a citizenship of a different country, but I wasn't aware, or I still want to retain my original citizenship. Could you not do that?
You could not do that if you took up citizenship without obtaining the permission to remain a South African citizen. You see, that's the important thing. So there was a mechanism, which was the argument in the High Court by the department, that there were mechanisms in place that prevented automatic loss. It's not like you weren't given the opportunity to apply and get the confirmation and thereafter take up citizenship. But the Supreme Court and the Constitutional Court said, notwithstanding the built-in safeguards, the notion that you automatically lost it. Let's say you never applied, as Mr. Plaatje's case. He went, he fell in love, he stayed abroad, and he didn't know about this provision, so he couldn't apply to retain. So he went on with his life as a dual citizen, only to find out later on, oh, you've automatically lost it because you took up through a voluntary act, citizenship of another country. The court was saying that's too onerous a provision. You can't expect people to go and basically know the law and also to apply. And if you didn't apply, well, there's automatically loss. So it weighed up the benefits of citizenship against the automatic loss. And it found that it was too heavy a price to pay, that you automatically lost it, and therefore it declares that section of the Citizenship Act unlawful.
Ashraf, I've seriously run out of time, but I have to ask you this. I mean, South Africa would not have been the only country or jurisdiction to have a law like this before. Of course, it was invalidated today by the ConCourt. But how do other jurisdictions manage or deal with these things? And what are the arguments for terminating your citizenship if you've decided, for whatever reason, to obtain the citizenship of another country?
So there was an amicus curiae in this matter, a Dr. Steven Spaggia, and he came from Montenegro, and there was a similar provision to that effect, and he argued that an automatic ban on dual citizenship was not on internationally. And so the court referred to the comprehensive studies done in terms of international human rights law regarding citizenship. And, there was a comprehensive assessment of how other jurisdictions deal with it. There are certain countries that don't tolerate dual citizenship, such as India, China, and Cuba. So in those cases, that jurisdiction will apply in regard to their citizens. But certainly with regard to South African citizenship, the human rights implications was very, very high, and the right to access your other constitutional rights could not be subsumed against the automatic loss. And I think that carried the argument at the end of the day.
So the human rights considerations weighed heavily. Thank you very much, Ashraf Essop, an immigration lawyer, for your time and for your insights.